ask in anticipation. I failed to anticipate in anticipation of starting this meeting. Are we going to call the roll? Mark, you're on mute.
Yes, we can call the roll. I'll do so now. If you are here, please say so. To test your mic, among other things. I'll hand it back to Kristen. Start with Kristen Hickman.
Here.
Susan Brayton. I believe she'll be joining us a little bit later. Betty Jo Christian. John Duffy. E. Donald Elliott. Kevin Jones. Paul Kamenar. Ron Levin.
I'm here.
Albert Lynn. See, Albert's just joining us. Albert's just joining us. I'm assuming he's here while his mic's getting on. Mary McQueen. David Michaels. Stephanie Middleton. Jeff Manier. Can't make it. Alan Morrison.
Here.
Thank you. Judge Randolph Moss. Victoria Nurse. She should be joining us shortly. Lee Otis. Deborah Perlin. Judge S.J. Plager. Judge Eleni M. Rumel. Eugene Scalia. David Shanka. John Siegel.
Here.
Thanks. Steph Tatham.
Here.
Frida Tanuzzi.
Mark, I'm here.
Thank you. David Tressell.
Come on.
Thank you, David. Cheryl Walter. Kenny Wright.
Here.
Thank you. Allison Zeeb.
Here.
Thank you. And then, in addition to those, I see Joe Salome, Mosti.
Yeah, I'm here.
Great. And then I believe that's it. I see John Duffy has joined. If you are a member of the committee and I didn't call your name, or you didn't respond, didn't hear your name perhaps, please let me know now.
And Sharon Buccino as a project advisor is on as well.
Thanks, Sharon.
Hey, Mark. Albert, I may have joined after you called my name.
Thanks, Albert. Kristen, I think I can hand it back to you.
Okay, great. Thanks so much, Mark. And before we get started, let me just ask whether our acting chair and executive director, Matt Weiner, has any opening remarks that he wants to make.
Just a few thank yous. Just want to thank all of our members for joining us for this unusual summer committee meeting, especially Kristen, our committee chairs, our senior fellows and others who have submitted pre-meeting comments. I think it's Allison, Ron, Alan, and I think John Siegel as well. John, by the way, is now a senior fellow of ACUS. He's no longer a public member. His 6 years of maximum service having expired. Congratulations, John. I don't think it matters for purposes of this meeting, though, because you are still our consultant and you're only acting in that capacity at this meeting, and so on. And thank you also to Mark Thompson, who's taken over the staffing of this project from Bobby Achoa, who served us very well. Bobby, if you don't know, recently left ACUS to join the Department of Justice staff. So I'll just thank Bobby in absentia, assuming he's not on the phone. And then finally, just a word on next steps. Our expectation, I think I speak for Kristen, is that the committee will produce a proposed recommendation or revised recommendation by the conclusion of this meeting. And then I would ask the council to convene what I think we call an asynchronous plenary session, which is really just to say that the membership will be asked to vote on the recommendation later this summer by email, and that presumably will be an up or down vote. There won't be any opportunity for amendments. So with that, and my thanks once more to Kristen, I'll turn it over to Kristen to start the meeting.
Thanks so much, Matt. And let me also point out, so Bill Funk, who is on the call, we submitted some comments, tried to submit them to Bobby earlier in the week. They got lost in the shuffle of the personnel change. Mark has just sent out an email to all members of the committee with Bill's comments. If they haven't been posted on the website, they will be, but all the other comments that have been submitted from Allison, from Alan, from Ron, from Jonathan, have all been posted on the ACUS webpage in conjunction with this project. So if you're having difficulty finding any of those comments, that's where you can find them as we move forward in this meeting. Before we get started with the substance, so as everybody knows, as Matt said, we're here today on remand from the June plenary session to resolve a couple of issues with respect to the recommendation on clarifying statutory access to judicial review of agency action. Before we get started on that substance, I do want to remind everyone of the basic rules under which we are operating. ACUS members, their designated alternates, senior fellows, liaison representatives, and special invited guests have full speaking privileges and are able to unmute themselves to avoid background noise. I would ask that you keep your microphone on mute and either raise your hand using if you go to reaction, at least for me on Zoom anyway, if you go to reactions, you can see the raise hand button. If you want to speak, either raise your hand or you can also signal me in the chat that you would like to get into the queue to speak. And then once I recognize you, I'll keep a queue and I will call on you. And once I recognize you, then you can unmute yourself, and please then remute yourself when you're done. That will enable us to avoid, at least as much as possible, both feedback and other extraneous noises. For members of the public who are with us on this meeting, also please use the chat feature or signal me by raising your hand if you'd like to speak. I will turn to you at an appropriate point of the meeting if we have that opportunity. All of the ACUS members and designated alternates, senior fellows, liaison representatives and special invited guests have priority when it comes to speaking. But in any event, I will, if we have the opportunity and it's appropriate, then I will ask members of the public to speak. But in the meantime, I request your patience when waiting for your turn to speak. But otherwise, please just signal me. If you're not sure of your status, let Mark know either in the chat or by email, and we can confirm your status for you. In the event that we need to vote, please be aware that only members of the Judicial Review Committee, which includes government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsel, only those folks have a vote. Please do not vote unless you are a member of the committee. Mark and I both have lists of committee members. Since I'm running the meeting, it's a little bit difficult for me to check, but again, if you're unsure of your status, reach out to Mark either in the chat or by email. Regarding the chat feature though, we would really appreciate it if you could try to avoid posting substantive comments or questions in the chat area. It can be really easy to miss something as it scrolls along, and the chat, I'm not sure that the chat necessarily is saved in conjunction with the meeting recording. And so we'd really prefer that you not post substantive comments or questions there, and instead just signal to me that you have a comment or question that you wish to share. I also, Matt touched on this, but I do want to take just a minute to sort of remind everybody, at least from my perspective, where we stand with this recommendation. Just a couple of days before the plenary session, A question was raised regarding how the recommendation would work in situations where the agency asks for comments after issuing legally binding rules in anticipation of potentially making changes in response to comments received. This is sometimes, although not always the case, with rules that are labeled as direct final or interim final or temporary. So we've been calling this the direct final or interim final rule problem. That's a bit of a misnomer because it's really an issue, or arguably an issue, that arises when you have a post-promulgation opportunity for comment, irrespective of the label that's being used. Regardless, we tried to work out some wording to address this issue, both in the days leading up to the plenary session and then at the plenary session itself. But we just weren't able to resolve the question to anyone's satisfaction, given time constraints at the plenary session. So the recommendation was remanded to our committee with instructions to resolve the issue, after which the plenary body can take a vote by email. So our primary purpose today is to resolve this post-promulgation opportunity for comment problem, although there's some debate over to what extent it is a problem. In order to make it more likely that we can achieve the plenary vote by email smoothly, I would really like to avoid making other changes to the recommendation as much as possible. That said, as you may have seen, if you reviewed the staff memo that was circulated by Bobby Ochoa last week, when he reviewed the video of the June plenary closely, he noted a couple of other minor changes that were proposed but kind of got lost in, the rush to wrap up this recommendation. They're minor enough that arguably they probably could have just been resolved by the Committee on Style, but they're just substantive enough that since we're holding this committee meeting anyway, we decided to go ahead and run them through the committee as well. That said, many of our committee members are only able to be with us today for the first hour to hour and a half of today's meeting. In the interest of having their full participation on the primary issue, that post-promulgation opportunity for comment issue that prompted the remand in the first place, I propose that we take up that question first. That said, one of the other proposed minor changes is in recommendation 2, which we're going to have to deal with in conjunction with the post-promulgation opportunity for comment issue. So I imagine when we're dealing with recommendation 2, we'll probably deal with both of those issues together, as we have a tendency to do. But then last but not least, we'll deal with a small change proposed by Jonathan Siegel in recommendation 4G. Does anybody have any questions about how we're going to proceed, or what, where we stand based on all of that windup? Okay, I'm not seeing any questions, so let's turn to the post-promulgation opportunity for comment issue. So the vast majority of the recommendations that we have received have been with respect to that particular issue. There are actually 3 places in the document that's up on the screen where this issue has to be addressed. One is in the preamble on lines 49 through 52. Then we've got language in recommendation 2 and language in recommendation 4B. Before turning to the recommendations themselves, because the language is fairly similar in all 3 places, I'm just going to say let's start with the first one and the preamble language. The vast majority of comments that were received and posted on the ACUS webpage have to do with this post-promulgation opportunity for comment issue. The comments that we received, or the communications we received, are fairly extensive, and so it's a little bit difficult just to summarize them. They don't all concur with one another. They all have different proposals to them. I greatly appreciate everybody sending in their comments, and I hope you had an opportunity to read them, because there was a lot of really good discussion in those comments. But rather than trying to paraphrase them or summarize them, I think it's probably best, since all of the participants seem to be present and with us, just for us for me to ask people who submitted comments to give us their thoughts. We have proposed language that we came up with. As you know, I can't remember if this language is precisely what I had proposed before the plenary session, or whether it got tweaked a little bit in the plenary session, even if we didn't wrap it up. This was at least a starting point for our discussions. At least from some of the commentary received, one observation that I will make with respect to this proposed language is that, notwithstanding the fact that I wrote it, I will observe that even though it specifically references direct, interim, final, and temporary rulemaking, in which an agency seeks and addresses comments after publishing rules in the Federal Register, it's true that it occurs, and it was, the point was made, I think, that, such is not always the case with direct, interim, final, or temporary rulemaking. Sometimes comments are sought, sometimes they aren't, sometimes comments are addressed, sometimes they aren't. These labels are not necessarily, they're not labels that are in the APA. Some of these labels, like interim final, does appear in at least some organic statutes, as does temporary rulemaking appears at least in the Internal Revenue Code. But at the same time, I also recognize that sometimes agencies use them without them being statutory terms. So one suggestion that was made was that I think rather than specifying, rather than specifying action by label, instead describe what we're really talking about here, which is rulemaking in which an agency provides an opportunity for and addresses comments after publishing rules in the Federal Register. Here in the preamble, we can say, such as direct, interim, final, and temporary rulemaking. So I'm going to propose modifying my own language as a starting point, if that's okay. So again, that would start off, we would delete direct, interim, final, and temporary rulemaking. At the start, it would just be rulemaking in which an agency provides an opportunity for and address, actually just provides an opportunity for comments after publishing rules in the Federal Register, comma, such as may be the case with direct, interim, final, or temporary rulemaking, comma, and then the rest of the sentence, may raise unique issues with respect to the timing of judicial review. With that, Jonathan Siegel has requested the floor, so I'm happy to turn it over to him.
With regard to what you just proposed, Kristen, I like the idea of describing it by what's happening rather than using the names, which, as you say, are not statutory. But surely we'd have to put the word final in between publishing and rules, because of course the basic rulemaking process always involves publishing rules and calling for comment. So we're talking about cases where the final rule is published. Yeah. So I would just propose to put the word final in there between publishing and rules. And the other thing I wanted to say is just, we're in this situation because I originally proposed in my report to cover a fairly straightforward issue, which is when the time to seek judicial review runs from the issuance of a rule. The statutory term is often issuance or promulgation of a rule. What is that? And I just wanted to say it should be the time the final rule is published in the Federal Register, not, as some agencies have suggested in some cases, an earlier date when the rule is issued internally at the agency, but the public may not even know it. So that's where this all came from. And then just before the plenary, Allison and Nina very helpfully pointed out that that could have unintended effects in these cases that we're now describing as indirect and interim final rulemaking. So now we're trying to deal with that. And I think it's very good that we're doing it, but we just have to remember that we don't have a report. I mean, my report did not cover this. So it's a little dangerous, but I think it is good to try to deal with it.
Next in my queue, I have Alan Morrison. Alan, go ahead, please.
Thank you, Kristen. I was going to make a comment along the lines that Jonathan just made, except I'm not sure that using the word final is helpful, because they may say it's not final because it's only interim final. I think the point we want to get at is that it has immediate effectiveness, which is what the problem is. And so I don't know how to, maybe with immediate effective date, or immediate or interim effective date, or something along those lines. But I think that's the point that we want to make. And final may be inclusive in that, but it may not. Thank you.
Yeah, Alan, I do take your point. One thought that had occurred to me in response to what Jonathan was saying was that for some, if something's labeled as direct final, then in some, then in some respects, does that make it final? Final is kind of included in that label. So, I do think describing what we're concerned about, which is rules that are immediately effective, I think what we're trying to get at is if they're immediately effective, we want people to be able to, we don't want to suggest that we're cutting off judicial review as of the time those, simply by, normally I think when you have rules that are put out that are labeled interim, final, or temporary, or something of that ilk, you can go ahead and challenge them in court. And we don't want to suggest that we're suggesting otherwise. We're just wanting to extend the limitations period so that you don't end up having to, you don't end up in this catch-22 situation where there's a suggestion you need to go ahead and seek judicial review, but then because the agency has requested comments and you're submitting comments and you don't know when the agency is going to respond to those comments necessarily, you could find yourself in a position where a court says, well, you can't challenge until the agency's done looking at the comments, but then the limitations period has passed. So that's what we're really trying to get at.
Kristen, the words immediately effective, which were my words, are not, the concept I want is effective during the comment period. That may become effective, because otherwise the agency say, oh, we'll make it effective 15 days after we issue it. That's not immediately effective, and therefore it doesn't come within the rule. So that's the concept I think is the right one on this. And I'll come back to you on the premature point when we get to it.
Sure. Okay, we've got a lengthy queue here, so let me turn to the queue and I'll shut up. Bill Funk, please, go ahead.
Well, first of all, I have to disagree with Ellen, because direct final rulemaking has a delayed effective date usually, and the idea is we wanted to delay the statute of limitations for the period of time between the publication of the rule and the delayed effective date. So if they gave 30 days of a delayed effective date, we wanted to extend the statute of limitations by 30 days from the date of publication, in addition to the regular time. So it's not it's not immediately effective in many of these cases. So that's one issue. The other issue is that if we're talking about something that's immediately effective, and we're going to now, but they say, but send us your comments, we may change it because it's an interim final or it's a temporary rule. So we might change our mind. So send us some comments. The point is there's no time that's specified. And in fact, as in the little sister's case, you never find out when it goes. It goes on forever. So I don't see how you can extend the statute of limitations by any period of time when there is no period that closes the comment period.
Bill, do you have language that, or a suggestion for changing the language that would address that concern? Because I see your point with direct final rulemaking, but I see Alan's point with respect to interim final rulemaking.
Well, I do have proposed language, and the proposed language is when an agency issues a rule with a delayed effective date without having provided prior notice and an opportunity to comment on the rule, Congress should extend the time for seeking review by the length of period up to and including the time between the publication of the rule in the Federal Register and the effective date of the rule.
Actually, is that language for the preamble or is that language for the recommendation?
That's language for the recommendation, but I would suggest that really the only issue we really can address, I think, is where we have a delayed effective date, where there's a set period of time that's going to close the comments. But typically, in the interim final rules, they don't set a dead date for when the comments have to be received. In which case, the comments they'll just consider them, and they'll consider them forever. But when that closes, we just don't know. So I wanted to take out all references to direct, interim, temporary. Just deal with the particular problem of where you have a delayed effective date during which you're supposed to comment.
Well, I disagree with you that interim final always leaves it open-ended. In my experience, some interim final or temporary rules actually do provide a specific comment period. And at least one statute that I'm familiar with puts a time limit on dealing with those comments. So,
but it doesn't put a time limit on when the agency will consider them and finish considering them. Or
in this instance, it does. That's the Internal Revenue Code, where it has a 3-year period or the temporary rule is no longer effective.
Well,
That's different. That's different.
Okay. I mean, but that's what I mean, and this is to some extent Jonathan's point about the fact that we don't have, this wasn't covered in his report. So consequently, we're sort of flying blind here in terms of our different experiences and understandings of different statutes. Let me turn to Allison, who is next in the queue.
Okay, so this issue, Nina first thought of it, and she and I first started discussing it because it came up in a recent case, which the DC Circuit dismissed, in which there was a direct final rule with an opportunity for comment from the CPSC that said, I forgot the date, so let's just say it was January 1st, and it said, you can comment until January 31st, and unless we get comments that change our mind, the effective date is January 31st. So somebody submits a comment, they don't sue, because they think, hey, maybe the agency will pay attention to my comment, and the agency doesn't make any change, the rule just goes into effect, but they didn't sue. So, if they had followed what I think is clearly the law, they would have sued in advance. And there's nothing ambiguous. But I think part of Nina's point was, why do you want people to sue in advance, which costs time and money to hire a lawyer and have them prepare a petition and all that? If the agency is going to change the rule anyway, you shouldn't want people to sue in that situation. So I think that situation is somewhat unique, not unique to that case, but unique to the situation of a direct final rule. I don't think that we should be addressing interim final rules. I don't think this situation is presented in what agencies call interim final rules. And I'm really worried that if we mush all these different categories of non-notice and comment, regular notice and comment rulemaking type rules together, we're going to have unintended consequences that is going to be more harmful than helpful or raise more questions than we have answered. So I think it would really be wiser for us to address only direct final rules or things with that effect, and to have the sort of the narrowest possible, what I guess we would call fix for this CPSC problem. I think we could probably do that with some version of Kristen's original language in the recommendation. I had suggested something that didn't talk about what type of rule we were talking about, but was really just more descriptive of the problem that Nina identified, which is that where the effective date of a final rule is the same as the last date of the limitations period is extended. Now, Nina replied to me after I said that and said, well, what if there's only a 7-day difference? I mean, the bigger the day difference, the less sympathetic or the less need for a change, but we could say where the effective date of a final rule is, within 10 business days of the last date of the limitations period should be extended by 30 days. And that way we would avoid having to talk about, does the agency call this direct final? Did the agency call it temporary? Did the agency call it interim final? We wouldn't have to worry about the nomenclature because we're just describing the situation in which we think there should be an extended limitations period. If we are going to actually name types of rules in the recommendation, then I would suggest we limit it to direct final rules. Because I think if we start talking about interim final rules, we're actually messing up something that currently has no problem.
Next in the queue is Ron Levin.
Yeah, my thoughts are somewhat along the lines of Allison, but I'm going to go further and suggest that the sequence in which you have in mind we should address these issues, Kristen, is not optimal. I don't think we should be massaging the preface, the preamble, before we decide what the substantive conclusions we're going to adopt are. We should look at the latter ones first. Also, I've suggested that paragraph 4 is more central and paragraph 2 is something which may or may not follow in its wake. And I further suggested that direct final rulemaking and interim final rulemaking are very, very different animals. And it's not a good idea to try to put them all into one sentence. And we would do better, I think, to try to decide what we want to do with each of these animals on a more general level before we try to see whether the language that's been put forward will or will not fit that. So I wonder if we could maybe modify the procedure to accommodate that, because it's not at all clear to me you want to do direct final and interim, assuming we do both, that you want to do both in the same sentence, because in direct final rulemaking, you don't expect post promulgation comment. You only invite objections. Well, you can call them comments, but they aren't really addressed to the substance. It's whether the rules, there should be a regular rulemaking. Whereas in interim final rulemaking, you're talking about actual comments. They're really different because the contemplation is direct final rulemaking is supposed to be the end of the road unless someone objects. Interim final rulemaking, it contemplates that there'll be a later deliberative time. I wouldn't put them in the same sentence, probably. And so I think we should take up these issues on a more conceptual level, and then once we figure out what we want to do, see whether the language we have would work for them.
I don't have an objection to dealing with direct final rulemaking and interim final rulemaking in different sentences. I will make this, I mean, Ron, even in your own memo, you talked about, I think it was your memo, you talked about whether you call it an objection or you call it a comment. You talked about a situation where somebody submitted the agency sought significant adverse comments and then decided one wasn't a significant adverse comment, so didn't respond to it. We could label it as comments or objections in order to be more inclusive. But I don't think it's quite right to say after indirect rulemaking that, that objections is somehow mutually exclusive of comments.
Well, I think comments are a statutory term. They trigger statutory procedures. I have at least taken the position, which people don't have to accept, that that is not a separate comment period. Because if it is a separate comment period, you've got to do a lot more to comply with Section 553. So I view the objection period as more of a request to reconsider the original rulemaking. And so it is not the same as interim final, where, at least as I think of it, you've adopted a final rule on day one, right? Because there was good cause to put it into effect immediately. And then you have what I would think of as a new rulemaking, which begins at the beginning of the post-promulgation period and winds up at the end of the road. I mean, Kristen, this is the Little Sisters situation exactly. You are taking something that we are now conceptually seeing as an NPRM in reality, even though it wasn't styled that way. So there you've got two different proceedings, really.
Sure. Which, I take your point about addressing them in different sentences. The next person in the queue is Drita Tanuzzi. Please go ahead, Drita.
Hi, Kristen. So I think my concern is the inclusion of temporary rulemaking, because technically speaking, as you know, we have that unique statute which allows us to both issue a temporary reg plus proposed reg, and any comments that would come would be with respect to the proposed reg, not the. I mean, I suppose they could be addressing the temporary reg if there's complete overlap. So it just seems incorrect to put a temporary rulemaking concept in this sentence. Now, I'm not at all addressing the issue of the Anti-Injunction Act, which also would call into question whether this has any value there at all, which is a hotly contested issue.
Sure. At least I don't know that the IRS is the only agency that uses the term temporary rulemaking, which is one of the reasons why I also think rather than relying on labels, we ought to, and why I've got this language may be the case, because, rather than dealing with labels, which can be variable and aren't statutorily defined consistently, if we describe the problem instead, we're probably better off. I will say my experience with the tax context, which I think, as I think you're aware, usually the notice of proposed, when you have a temp reg, the notice of proposed rulemaking simply cross-references the temp reg and doesn't actually contain a whole lot in the way of substantive language in it. So are you really replying to the notice of proposed rulemaking, or are you replying to the temp reg? In any event, and we can argue the Anti-Injunction Act on another day. But can
I make a quick comment about temporary?
Yeah, please go ahead, Allison.
You asked whether other agencies use it. I did see that DHS has some, but they are called temporary because they're rules that say the fees will be this amount until January 31st of 2023 or something like that. So it's just that it has sort of it's temporary in that it has sort of an expiration date for purposes of CFR or whatever, which seems to me a different, but still goes through notice and comment. That seems to me different than what we're talking about here. So that's why the word temporary sort of stuck out to me.
That's one of the reasons, again, why I think it makes sense for us to describe the problem rather than relying on labels. Although I still like the idea of at least mentioning the labels that many people are familiar with, if for no other reason than to recognize what we're talking about, even if, we use fudgy language like may be the case with, or something like that, to say may, or which means it may not be the case with in some circumstances. Next in the queue is Steph Tatum. Please go ahead, Steph.
I withdraw my comment, but I do think it does. I would like to support Ron Levin's recommendation that we discuss the recommendation and agree on where this is going before finalizing the preamble language.
I have no problem with that. I have I like going and things in order in the document, but then at the same time, and to me, the language is very similar between them. But on the other hand, I have no objection to turning to the recommendation itself. I don't know whether 2 or 4B is really, Ron suggested we should start with 4B. To me, there's not a lot of difference between the two in terms of, they deal with slightly different circumstances, and yet at the same time, the language is very, very similar. I guess let's go to 4B because 2's got this other issue in it. And so rather than trying to get absorbed into 2 separate issues simultaneously, maybe 4 is the better place to deal with it. So, fine. We still have this issue here about, instead of using the labels, to address situations in which an agency, I don't know, Mark, if you can pull some of the language that was that we had up in the preamble to put in here to try to, capture some of the things we've been talking about so that we're tinkering with the right language, if you will. That may be helpful. Bear with us, everybody, while we kind of get our ducks in a row with the language. To address situations in which an agency provides an opportunity for comments after publishing rules in the Federal Register. So it needs to start with to address situations in which an agency. And I know other people have suggested other things, but I need help with other people suggesting actual language. But let me call on John Duffy, who's next in the queue. Go ahead, John.
So I had a pretty specific question about the language, whether it be in 4B or in 2. But so we're on 4B, and you said the extension of the time period that's contemplated here is up to and including the effective date of the rule. And I'm just not so sure how that helps. It actually would have worked out in the Willis case, which is one of the things that's prompted this, but that's just because of the oddity of the dates. So let's say an agency goes direct to final and says, we're publishing the rule today, it's effective today. We find all the necessary good cause to both waive the comment period and waive the requirements in 553 as to delayed effective date of the rule. It's effective today. But we're going to have 60 days to, where people can file objections. And if somebody files an objection, we'll do something else. We may have a true notice and comment rulemaking, which is sort of what they said in Millis. And then it seems to me this fix doesn't extend the time period at all for judicial review in that case. And if, as in Millis, the statutory period was 60 days, the day the comment/objection period runs out is exactly the day that the time for judicial review is jurisdictionally closed. So I don't see, I just don't see why adding this extension helps if the agency makes the rule effective, there's no extension, right? Am I reading this wrong? I'm just not understanding it, maybe. You're muted, Kristen.
That's the way I read it too, John.
So I think there's a part of it is when I'll admit, when I was originally drafting language, I was thinking more in the vein of the agency I was thinking more in the vein of the interim final rule scenario where an agency puts out regulations that are legally binding, accepts comments afterward, and then there's some later point. It's fine. It's immediate now, but then or it's effective now, but then there will be something else later that comes in, and some people might want to wait until you get to the final rule before suing, but with the fact that it was published in the Federal Register as an interim final rule trigger the limitations period such that before the agency could finalize based on comments, you would, the limitations period would be over. Whereas Allison and Ron, I think, are talking about a situation where an agency puts out a direct final rule with a delayed effective date.
Well, I think Allison, I think, is thinking about that. Maybe she can speak for herself.
Yeah. And so
I
my
think
language didn't really address her situation, I don't think.
Yeah, and I always thought, I think it's Ron or maybe Bill, I thought that the interim final rule, I always thought the law was pretty clear on that. It's pretty logical. If you want to challenge the interim rule, you've got, however many days to start seeking judicial review, because that interim final rule, that thing is going into place and it's going to have legal effects pretty soon. And you better challenge it if you're not going to be happy with it. And if you don't challenge it within that time, well, you're leaving it up to the agency. The agency might take, 60 days for it to be interim. It might leave it as an interim rule for 2 years.
Well, but what if the agency puts out then the final rule?
Well, then I think you challenge that.
That's not usually done. That's not usually done. They don't do in an interim final rule. They don't do another rule. They just say we're not changing it. It's staying in effect. We're not changing it.
But I think when they say that, they have to publish that in the Federal Register, and maybe it's incorporating by reference its earlier rule, but that's its new notice that this thing, which is called interim, is now final.
See, I think that's the $64 question, though, is, if in that sort of a scenario, does it trigger a new limitations period with respect to the language that's been in effect for a period of time, right? And I'm not sure that it does. And especially if, if they label something as interim final and then they don't, sometimes what happens with these things is they label it as interim final, they request comments, and then they never formally finalize it. It just stays on the books as the interim final. And yeah, you could say, just challenge the interim final rule. But especially if you're participating in the comment process, I can understand why some people would like to, are you saying that they have to sue and participate in the comment process simultaneously?
Then it seems the way to deal with this is to just hold the statute of limitations during the comment process as long as the agency keeps it open, because that's the sort of clear way to deal with it, rather than to deal with it, to add on the whatever delayed effective date, which could be 0 days of delayed effective date.
Sure. I've got, in my queue, I've got Steph Tatum and then Allison Zeeb. So Steph, go ahead, please.
2 points. One on the question of agencies finalizing their interim final rules. I don't know that I've seen anything more recent, but I am aware of a 2012 GAO study looking at this empirically. So in that study, they found, I think that it was about 72% of the agency IFRs are finalized ultimately with response to public comment, but of course the other percentage were not. And OMB's official position on that, articulated by then acting administrator Boris Burstein, was that the decision of whether to finalize an interim final rule should be case specific because there are varying circumstances, limitations, and agency resources, and so on. So just as a factual matter, I think there are some that ultimately are never finalized, perhaps even as high as 1/4 of rules. The second point I would make, though, is just, what is the point of tolling to give them time to prepare comments and not have to be simultaneously filing for judicial review, or is the idea that the agency would have time to respond? Because I don't think that tolling by the length of the comment period is really going to give the agency time to respond and address. I think if you looked at how long it takes an agency to respond to interim final rules or comments on interim final rules, it would be at a minimum the comment period plus some extended period of consideration and review. So just trying to understand and moving that day forward what the goal is.
Sure. I think one problem that was recognized is the idea that there's some question about if they do, if they issue some statement but not a whole new set of rules, then what does that do with the tolling period, or what does that do with the limitations period, not the tolling period? Allison and then Ron Levin. Go ahead, please, Allison.
So first, Stephanie's last question. The concern, the reason Nina first raised this concern was for the benefit of potential commenter litigants, not the agency. So she was concerned about the unfairness potentially of someone who thought, well, my comment's under consideration for this 30-day period, when it turned out that the agency was just going to finalize. In the CPSC context, the rule becomes effective unless they say otherwise. So in the Melise case, the people didn't know until 30 days passed. I mean, this is the theory, that they didn't know until 30 days passed and the rule became effective without further action by the CPSC, that the agency hadn't deemed their comment worth changing the rule. More generally, this whole conversation makes me really concerned that we are sort of trying to cure a problem that doesn't really exist. We've only flagged so far one case in which a litigant maybe was confused by the process and therefore blew the statute of limitations. And it was a case with a direct final rule that had a short effective date that was exactly the same period of time as the statutory statute of limitations, because the CPSA has a 60-day statute of limitations. So for most APA rulemaking, you don't have 60-day, such a short statute of limitations, and it's not really a problem. Also, for interim final rules, I just don't think we have examples of that being a problem, and I don't think it's a situation that we should try to be addressing. They are often finalized, and if you're going to wait to see what happens with an interim final rule, if we're going to extend the comment period, the statute of limitations, because someone doesn't know what's going to happen when the rule is finalized, when a final rule is going to be issued after notice and comment, and that could mean that the rule is the interim final is in effect for years, and there'd be sort of no end to the statute of limitations. If you want to sue over an interim final rule, which is a general matter, it also comes with an opportunity for comment, you should just go ahead and sue. I think it's different than the situation in Melise, where this rule was final. They didn't promise to do any further rulemaking. The interim final situation is more commonly like in the Little Sisters of the Poor case, where they sued over the interim final, and then later there was a suit over the final as well, and that's all fine. But you shouldn't, there's no reason to mess around with the statute of limitations for suing over an interim final just because there's a comment period that is sort of in aid of a later final rule. Whether or not the agency gets around to issuing it, whether it's 75% or 80% or whatever, the interim final rule is the final in effect rule. And in some sense, you're not commenting on that. If you want to challenge it now, because your comment really goes to the later final rule that the agency has said it's going to issue. It's not going to alter the interim final rule because the interim final rule is the interim final rule. And again, I just feel like we don't have examples of problems with the statute of limitations in suits over interim final rules. So I just really want to discourage us from messing in that area.
So let me ask you this, Allison, if I'm understanding your comments correctly. In addition to taking out all references to interim final rulemaking, which I may be coming around to the extent that you talked about addressing an issue, or providing a solution for which there is no problem. Did I understand you correctly to say that perhaps notwithstanding even the one odd case that gave rise to Nina's comment in the first place, that perhaps that's such an outlier that we don't need to address this issue at all, at least in the recommendation?
I think there's a decent argument for not addressing it at all. And depending on what language we came up with, I might prefer that option. I'd prefer not fixing the problem in Melise versus CPSC to doing something that could potentially have consequences that are broader than we've anticipated. If we are going to do something though, then I recognize that this suggestion hasn't gotten much traction, but if we are going to do something, I would do something that doesn't, that is more descriptive of the problem that Nina first identified. And unfortunately, she couldn't attend today. She had a conflict. But the problem being that the effective date of the final rule was the same as the limitations period. It's an unusual situation. It's the one that prompted this whole discussion. And if we're going to make a change, I think we should stick to that unusual situation.
So let me just throw out there for discussion purposes, and then there are still some more people in the queue, the possibility of taking out altogether any changes with respect to this collection of issues from the recommendation itself, and perhaps just dropping a footnote in the preamble, recognizing that there are some circumstances, whether it's direct final rulemaking, we could or don't have to include interim final rulemaking in that mix, but just recognize that there is a subset of rulemakings that may raise, doesn't necessarily have to raise, but may raise unique questions, and that this recommendation is not intended to address. Particularly since John's original study wasn't dealing with these situations to begin with. That might open the door for a future study and a future recommendation. But for purposes of this recommendation, we could stop playing the guessing games that we're all playing here and trying to figure out what different scenarios are out there, and avoid the problem altogether.
You know what? I'd be happy with that, but the one other thing I thought of is that we could say that where the agency's statute is undertaken pursuant to a statute, where the agency's rulemaking is undertaken pursuant to a statute that has a relatively short statute of limitations, Congress should consider mechanisms to ensure that the statute doesn't expire before people have something or other. Okay, that was inarticulate, but I hope maybe Ron understood.
Yeah, Ron's next in the queue, so go ahead, Ron.
Now, I wanted to ask Allison to clarify something, which is, what did the CPSC's statute say with regard to the statute of limitations?
It's 60 days.
From
and
what?
So
from what?
It was 60 days from the publication of the final rule. The final rule said, is a direct final rule that said promulgation. So everybody agreed when the 60 days was. The problem was that the effective date was also the 60 days, and the lawyer thought he could wait until after the effective date.
Yes, okay. So here is my comment, and I have comments on both direct final and interim final, but if you want me to deal with only the former, I could do that for now. The whole point of direct final rulemaking is supposed to be that it is not effective. It is not final on the date it's issued, because you're saying we are provisionally doing this, but until we hear whether there are objections, we aren't definitively saying we're committing ourselves to it. And so you can't have an effective date until the objection period has run out. Now, they did that wrong in Melise, right? But that's what direct final rulemaking is. So what this may mean is I'm really supporting the idea that maybe the way to deal with it is just in the preamble that says we don't have to deal with a statutory language. We say, but you know, things can get complicated in a direct final rulemaking situation because the agency puts out something subject to hearing objections. And so it's not final until it is determined that there were no objections that would confirm its belief that it was non-controversial and notice and comment was unnecessary. Now then you could cite to the ACUS recommendation, which would support that. Melise wouldn't support it, but the template that direct final rulemaking is supposed to follow would. But regardless, you wouldn't be legislating. But maybe the preface is the right place to deal with it because Allison, I tend to agree with Allison. It is such an unusual situation that maybe you don't want to legislate where you don't typically have a problem.
Okay, next in the queue, we've got John Siegel to be followed by Bill Funk and then Alan Morrison. Go ahead, Jonathan.
Thank you. Well, I'm going to make a radical suggestion that I think takes the suggestion that Kristen made and goes even further, because the more I listen to this discussion, the more I'm worried that we're really on a dangerous path. I mean, as I said earlier, my report dealt with, a very simple situation that had a simple solution. Then someone pointed out that solving that might break something else. I thought maybe we can just deal with the something else, but the more I listen to this discussion, the more I'm concerned that there are just too many permutations. We don't have a report. We aren't correctly anticipating all the situations where this might apply. So if you think back to prior situations where we faced this problem, the usual solution has just been to cut whatever we feel we don't know about. So just cut it back to where we're comfortable. So in this situation, I see two possible ways to do that. One is sort of along the line of what Kristen was saying, which would be to cut back recommendation 2 so that it would say something like, where the event is the promulgation, amendment, or repeal of a final rule that has gone through the normal rulemaking process, the date shall be the date of publication. And even more, and then maybe we'd have a footnote or something in the preamble that says, Congress might want to think about what to do in situations that don't follow the normal pattern. Even more radical, we could just cut back number 2 to say, Congress should clearly specify what event starts the time for seeking review, period. And 4B would be cut entirely. Now that would mean sacrificing the solution that I was recommending for the simple problem. But frankly, even that is not all that necessary in that, the cases that I found addressing that problem, the courts got it right. I didn't find any case where anyone was actually deprived of a right to review based on this problem. So, maybe I'm being a little radical here, but as I say, the more I listen to this discussion, the more I'm concerned that we started with something very simple. Now we're trying to solve the much bigger problem of how time limits should work in the case of direct and interim final rulemaking. And we don't have a report and we don't know all the permutations. And I think we should just stay out of it.
Bill Funk?
Well, I'm with Allison and Jonathan as I see the idea that I always thought we should get rid of the interim final rule stuff and only deal with, if anything, the direct final rule. And as Allison correctly points out, it's a rare situation. But of course, most of the technical amendments we're making here relate to rare situations. But I think that Jonathan's idea of saying that this number 2, paragraph 2 and 4 for that matter, would only apply where the normal, it's the date of publication in the Federal Register where it's gone through normal notice and comment. And then in the preamble say, in cases where it's not a normal thing, there can be problems. And then you just cite to Milisi or Malich, or however you pronounce it, as an example of how this can go awry if they don't go through the normal notice and comment. But I think the simple solution that Jonathan suggests of conditioning 2 and 4 on going through normal notice and comment rulemaking is a good idea.
So Jonathan offered 2 suggestions, one which would have, which would include that second sentence in 2, for example, to say where they've gone through the normal notice and comment rulemaking. But then also he suggested deleting everything after the first sentence. Which do you think would be better, Bill? You're on mute.
I think the first one is the better solution. That is.
So Jonathan, can I task you with coming up, while I'm running the queue here, can I task you with coming up with what the language of that second sentence ought to look like in order to say it's gone through the normal notice and comment rulemaking process? That's a little bit more formal than it's, the normal notice and comment rulemaking process.
Okay, let me see what I can do while you're going through the queue.
See what you can do while we're going through the queue. Let me turn then to Alan Morrison.
So I normally don't think of the word Jonathan Siegel and radical in the same sentence, but I will accept it for this proposition, this purpose. And I would favor the less radical of John's 2 radical suggestions. But having said that, and I agree that consensus by subtraction in this case is a better idea than consensus by addition. And so I favor that general approach. I would like us to say something in here that agencies that put it, if we have this footnote that we're not talking about this, I'd like to be able to say something that agencies that promulgate rules with effective dates while they are still seeking comments or objections should not be heard to say that anyone who files a lawsuit in that time is doing so prematurely. That is.
Are you okay with doing that in a footnote in the preamble?
Yes.
Okay.
But my basic point is I think that if it's clear that people can sue, they will sue if they have a claim, and that I think Nina Mendelson's concerned that people shouldn't be forced to sue because they have to get a lawyer and pay the filing fees. They're going to probably have to do it at some time anyway. We're not talking about ordinary citizens who are on top of these. We're talking about groups like Public Citizen or the Chamber or somebody else who's going to file a lawsuit anyway. They've got lawyers on top of this as soon as they found out about it, and at least the court can decide what it wants to do in terms of deciding the question, but they shouldn't be tossed out on the grounds that they failed to exhaust administrative remedies or that it's not ripe. Thank you.
Okay. Next in the queue. So next in the queue is Ron Levin. So you go ahead, Ron.
Yeah, I don't want to dominate too much, but it seems to me that I'm heading toward the consensus by subtraction consensus, if such is indeed emerging, and it can probably be addressed by saying in the text recommendation, or maybe the preamble, this applies to regular notice and comment rulemaking. That's part of the language written into the recommendation. Where that is the case, the following things happen. And then the preamble, we say this recommendation is limited to regular notice and comment rulemaking. In other situations, which we're not addressing, things can get complicated. See the administrative conference recommendation and see Melise as to how things can get complicated.
Sure. Are you proposing we actually use the phrase normal notice and comment rulemaking in the recommendation?
No, I'm using it colloquially.
Okay.
right?
I think we
But-
are I think what I am sensing is that we are coming to a consensus that in the recommendation itself, we essentially go back to something very similar to what John had originally proposed, although we include some reference to, a more formal version of the normal notice and comment rulemaking process. John is working on language to that effect, which I presume is going to be forthcoming shortly. But in the meantime, let me just ask, does anyone on this call have an objection to subtracting, as we're discussing, in the recommendation itself, making clear that we're only talking about normal notice and comment rulemaking, and are using that language and not dealing with any of this direct or interim, final, or temporary rulemaking stuff in the recommendation? Let's leave the preamble aside for the moment. Does anyone have an objection to taking recommendations 2 and 4B back to closer to where we were originally? Okay. Let me ask then, John, how you doing on that language? You're on mute.
Well,
There you
how
go.
about this? It's a little long, but where the event is the promulgation, amendment, or repeal of a rule by an agency following the opportunity for participation by interested persons required by 5 U.S. Code 553C, Congress should provide that the event date is the date of the publication of the final rule in the Federal Register.
Well, it's long, but it's clear.
You like that more
We're
slowly?
getting a thumbs up from Alan Morrison.
I'll say it more slowly. So
Yeah.
we've got what is there already, where the event is the promulgation, amendment, or repeal of a rule. And then what's new is,
Actually, hang on just a second, John.
oh, sorry.
Mark, why don't you get rid of all of the language that's in red? I think we've agreed to get rid of all of that. Okay, now let's go, John.
Okay, so after repeal of a rule, we have by an agency following the opportunity for participation by interested persons. I mean, we could just say public participation, but I'm using the phrases that are in APA 553. So by an agency following the opportunity for participation by interested persons required by 5 U.S. Code section 553C. And then we have Congress should provide that, and then I would just put the word final in before rule there.
I have one problem with that. I like the idea. The specification of 553, I'm worried about because I believe there are statutes that require notice and comment specifically under their statute.
Well, that's a good point. Well, we could take out required by 5 U.S. Code 523. We could just say by an agency following the opportunity.
Or how about required by 5 U.S.C. 553C or similar statute?
That's fine with me too.
Right.
Well,
required by
I'd
law.
suggest we either, yeah, I was going to say either just say required by law, or why do
Or
we
what
have
if what
that?
if they
we
do it
think
even
that
though
if
it's
they
not
provided-
required?
Yeah, if they provide opportunity for comment, but it wasn't required, do we think
Right.
the answer is different?
Well, okay. That's why we have all these lawyers here.
You know,
Well, this looks, is this way
I
not
think
look
I'm
right?
fine with this. I'm fine with this. I'm not going to continue arguing about having statutory references.
Yeah.
They'll get the point, or not.
Or not, as the case may be.
I mean, don't
okay,
forget that the recommendation also calls for the office of the chairman to prepare an actual proposed statute that would accomplish
Yeah.
it. So
We're
there's
gonna-
yet a
we're gonna
further
cross that
drafting.
bridge. That's a whole
exercise.
different committee meeting, John. We're going to cross
Exactly.
that bridge.
That's not our
later.
job. We don't
That's
have to.
not, so, in any event, let's scroll down to 4 and look at 4B.
Okay.
And again, I think we want to delete all of the proposed language. Let's see, that starts the time for seeking judicial review is the promulgation, amendment, or repeal of a rule.
And then we just insert the same phrase.
Something very similar anyway. Yeah, okay. Publication of the final rule in the Federal Register. So we need the word final. There you go. Okay. Does anyone on the call have an objection to the changes that are now proposed for 2 and 4B, which are basically identical to one another? Any objections?
If I could just raise a question.
Yes.
So the use of direct final and interim final is accomplished through 553BB, where there is a statute that does provide for for notice and comment rulemaking. But nevertheless, by virtue of the exemption, the agency is also doing something creative. So it's a matter of precision of drafting. There is a statute. The statute does provide certain procedures where notice and comment was done. But we want to make, but we still have this question of what happens to those other forms of rulemaking. And I guess if the answer is we are excluding them from our jurisdiction and just commenting on them in the preamble, maybe that fixes it.
That's where we're at this point. Is
Okay.
We're not messing with any of that stuff at all in the recommendation. We're going to deal with all of the direct / interim final / temporary simply by language in the preamble, and we're making that carves all that out and
Got it.
says that's a different situation. That's where we're going next. But first, I just wanted to make sure that no one had any objection. With that understanding, we're now going to go deal with the preamble. But before we move to the preamble, everybody's okay with 2 and 4B? Okay, not seeing any objections.
Question with respect to 2, which
Go
is,
ahead, Bill.
that means we eliminated the other issue in recommendation 2.
Oh,
Remember-
we that's
did-
right, we did. Where the point was made that
some rules aren't required to be published in the Federal Register, and we weren't addressing them.
Right.
But if it's a rule that's gone through not normal notice and comment rulemaking, I think they all have to be published in the Federal Register. So I think we've dealt with that problem indirectly.
Yes, I would think so. John, what do you think? Because this was your proposal.
Let me just see if that other language could go in here. I mean, we could still add, and notice of the event must be published in the Federal Register, as we were going to after interested persons.
What rule, the following normal notice and comment rulemaking, doesn't have to be
Yeah, it's
published?
kind of hard to imagine that it would go through notice and comment, and yet there doesn't have to be something in the Federal Register at the end. I guess that's right. I see John Duffy has his hand up.
Yeah,
Well,
John, go ahead, please.
Well, but the language no longer is go through normal notice and comment. It's following the opportunity for participation by interested persons. That could happen in a rule, for example, of particular applicability, that you just give the few regulated entities that the rule targets the opportunity to participate. And that, you might not say that's not the normal process, but the language we're using is general. I thought that the end phrase, where the rule is so published, I thought that was the way we dealt with this issue.
It was. I had suggested an alternative, but given the way the sentence is developed, perhaps this is better.
Yeah, you suggested the alternative of sticking it up in the first clause, but now the first clause is so long, it's sort of awkward to stick it in there again.
Ron, I see your hand in the queue.
Yeah, where do guidance documents fit? Are excluded altogether because we're dealing only with legislative rules? Because if they haven't been excluded, then it too could literally apply, because they may often be issued following the opportunity for participation.
But do they
And
have
yet I don't
statute of
know-
limitations?
What?
Rod, do they have statutes of limitations that apply to guidance documents?
I don't know.
I don't think so.
You sure? It's an agency action.
Sure. No, but there would have to be a statute of limitations other than the 5-year general statute of limitations, which is not
Yeah.
what we're talking about here.
Okay, well, if that's,
I think that's right.
if you're right on that, then
Allison, I see you in the queue. Go ahead, please.
So now I'm concerned that if it's just following an opportunity for participation by interested persons, that does sort of implicate the Melise situation, because there was an opportunity for participation by interested persons. It's just the agency said we may or may not follow up on anything you have to say.
Well, but Allison, do you think that that will be covered by what we're going to put into the preamble, where we make very clear that we're not talking about that situation?
Maybe. I don't know, I guess I'm finding myself confused by what we're doing in number 2. I also wonder, because it says Congress should provide the event date as the publication in the Federal Register where the rule is so published, does that sort of beg the question of what the event date is where the rule is not so published? What is the rule so published? What work is that doing there?
Well, I think what we were, okay, so 2 things. Number 1, with the added phrase by an agency following the opportunity for participation by interested persons, we were trying to find a more formal way of saying that this recommendation applies when an agency uses normal notice and comment rulemaking. With respect to publication in the
Okay,
Federal
let me just
Register-
say, I think you're right. That isn't a problem for Melise, because the agency is not promulgating, amending, or appealing it following the opportunity for comment. It's actually doing it before the opportunity for comment.
Right.
So I think that part is okay. You're right.
And we're going to include language, we haven't done it yet, but we're going to go back to the preamble and either up in the text or in a footnote, do our carve out for direct final and interim final rulemaking or whatever, and cite the Melise case and cite the ACUS recommendation on direct final rulemaking and so on. So there will be an explicit carve out in the preamble. The other thing with respect to where the rule is so published, so even though ordinarily when you go through notice and comment rulemaking, the rule gets published in the Federal Register, there are some instances in which the rules are not published in the Federal Register. And so what we were just trying to do with where the rule is so published is to make clear that the event date would not be publication in the Federal Register if the rule is not published in the Federal Register.
But then doesn't number 2 beg the question of what the end date is, what the event date is for them?
Well, the main point
Yes,
of
it does,
2
but
is...
yeah,
hang on one second. The main point of 2 is that Congress should clearly specify what event starts the time for seeking review. And then in instances where we're promulgating a rule that's published in the Federal Register, that ought to be the trigger.
Okay, I'm with you now. Sorry, it took me a
Bill,
while.
go ahead,
I got there.
please. Bill, did you have something to add? Okay. So with that, everybody on board with 2 and 4. Okay, what I'd like to do at this point, because we've been going for almost an hour and a half, recognizing some people may have to leave, nevertheless, I'd like to take like a 5-minute break. And then we'll come back. Let's come back at 2:30 Eastern. So it'll be a 6-minute break. I'm going to call us back to order.
Kristen, I have to get off now. Thank you very much. Appreciate it.
Thank you, Alan. We greatly appreciate your participation and your comments and all of your input.
I'd like to see that essay though.
Yeah, I will.
Colin Jones.
Yeah. Consensus by subtraction. Don't forget.
Okay, so turning then back to the preamble. Everyone will bear with us while we pull up the preamble. Okay, so I guess the first question ought to be, are we okay with dealing with this issue in a footnote as opposed to the above the line text? That would be my preference, but I'm happy to entertain comments to the contrary. Okay, seeing none, I think, hang on one second, please. So I have two thoughts with respect to what we need to do here in the preamble. One is that we have made some adjustments to paragraphs 2 and 4B that I think perhaps we ought to acknowledge above the line, but then, or make adjustments above the line to reflect. But then as with respect to the direct / interim final / temporary rulemaking issue, you know, looking at where a footnote would go, I did this on the break, because there's already a footnote after the last sentence, you know, in the immediately preceding paragraph that ends on line 48. I would propose we put a footnote with respect to on line 46 after the immediately preceding sentence dealing with paragraph 2. And I think that will be clear enough, because since 4B and 2 essentially say largely the same thing, if we make a comment about what's not included in 2, it's going to be pretty obvious that's not included in 4 too, right? So the question then is the language to be included in footnote, what is now going to be the new footnote 11. Can I have somebody volunteer? Perhaps Ron Levin, since you have weighed in on this quite a bit, would you mind trying to come up with some proposed language while we also talk about the language I think needs to be added in this paragraph to address the changes in paragraphs 2 and 4B?
There is a maximum about good deeds being punished and the like. I'm willing to give it a shot if I know
we
what
just
it
need
is.
something to start with.
Yes,
Take a stab at it.
I wonder, do people have some idea of what it is we want to say, just in very general terms?
My own sense of the
leave it to me, and leave it to me, and then take shots at it afterwards. Is that what you want?
My own sense of the conversation, and perhaps you will disagree, is simply that we want to acknowledge that, you know, and I don't really care whether we do it by reference to label or whether we do it by reference to what's going on in terms of delayed effective dates or providing an opportunity for comments after publishing legally binding rules or what have you. You know, I think, you know, just saying something to the effect of, you know, those circumstances raise potential complications for limitations periods that are not addressed in this recommendation, and then CEG and a citation to the ACUS report on direct final rulemaking and the Melise case.
Oh, okay. Is there any, do you have any going in assumption about whether we limit this to direct final or maybe try to cover both?
My own preference would be to cover both. Since
Okay,
we're being very fudgy and saying may raise issues.
You're right. Understood. All right, I will work on something.
And don't forget Ellen's point about, you know, they can't get out of claiming that they have to exhaust remedies before they go to sue.
Yeah, I mean, we're also not intending in this report to say anything whatsoever about finality or exhaustion or, any of those justiciability doctrines.
Okay.
I think it's not enough to say that we're not intending to address them. We actually have to make sure that our changes don't affect them. Right?
Well, I mean, I'm not sure how our changes do affect them.
I think what we undid today shouldn't affect them, but I think we should not just say we don't intend to address them, but that we don't. Well, let me see what he finishes up with.
Yeah,
Perhaps we do not believe that the recommendation has any implications for justiciability issues beyond the limitations period. I don't know.
Well, Alan's point was that if you have a delayed effective date, right, and you have an immediate effective date, but you ask for comments, right, after that if somebody sues after the effective date, then the government can't say, well, it's not ripe yet because we haven't considered the comments. And if judicial review is triggered by publication in the Federal Register, then that's the time the judicial review possibility starts. And I mean, we do cover that.
I actually recall some case law that might be a little analogous here, where the agency says we're doing X, and writes to a government and say, here's what we're doing, and then it finishes the comment period. I mean, that doesn't. I'm not sure if it fits, but I think I heard what people are saying. So I'll see if
you see if you can capture that. The proposal that I have, Mark, tasking you to type, just to capture, I think, what we have just done in terms of additions to recommendations 2 and 4B, would be, let's see, immediately on line 43, before, as an opening to the sentence that begins paragraph 2. So no. On 43, right there, where an agency promulgates, amends, or repeals a rule after opportunity for participation by interested persons, then it says paragraph 2 also provides that in drafting specific judicial review statutes, providing for review of an agency rule, Congress should provide that the time for review runs from the rule's publication in the Federal Register, where the rule is published in the Federal Register.
Do you want a sentence at that point that says, in the rare circumstances in which rules do not have to be published in the Federal Register, this recommendation does not address those situations. This recommendation does not address those rare situations in which a rule is not required to be published in the Federal Register. In other words, we're saying only when it's published in the Federal Register, and then they make clear that we're just not dealing with the other situation.
I do think we need to say, or do we need to say, I don't know if we do or not, but with respect to, in order to think about guidance, since guidance often does not have to be published in the Federal Register, it's not exactly rare. Guidance is not rare. So, in which rules subject to notice and comment rulemaking do not have to be published in the Federal Register.
Instead of saying rare, then just say that this recommendation does not address situations in which rules do not have to be published in
Fine.
the register.
Yeah, then we could get rid of subject to notice and comment rulemaking.
Right.
And then for 4B, 4B provides that Congress should include in the general statute a provision that whenever a time period for seeking judicial review begins upon the issuance of the rule, and before the comma say, and the rule is published in the Federal Register, comma, then it says the time starts when the rule is published in the Federal Register. I think that captures what we're doing now with 2 and 4B. Thoughts, comments, concerns?
You should flag general statute there, all right, because that's another issue.
Sure. We're going to talk about the Sally Katzen comment. Why don't you just highlight that for now, Mark?
Kristen?
John, go ahead, please.
I think what you have here is fine, so I'm not suggesting a change in this, but just maybe this is really for Mark. When this gets transmitted to the full conference, I would just put a note in that transmittal somewhere saying, you know, that we solved this through consensus by subtraction. Just explain that to solve the issue that was remitted to us by the plenary, we just decided to limit what we're saying more carefully to make clear that we're not addressing that issue. And that'll also be reflected in the footnote that Ron is drafting.
Any other comments on this above the line text? Okay. Ron, how are we doing with our footnote?
Here's what I've got so far. This recommendation addresses judicial review of rules issued through a process in which the agency solicits comments and then publishes a rule after consideration of those comments.
Ron, I'm sorry, for transcription purposes, my court reporting has not gotten.
Mark, I want to read it for people's reactions, and then if it flies, I'll do it slower.
Okay.
Okay. Should I start over?
Yeah, go ahead, please.
Okay, starting over. This recommendation addresses judicial review of rules that are issued through a process in which the agency solicits comments and then publishes a rule after consideration of those comments. The recommendation does not address situations such as direct final rulemaking and interim final rulemaking, in which the agency publishes a rule in the Federal Register, but invites post-promulgation comments or objections. See ACUS recommendation 95-4. Those situations can present problems of determining the effective date of the rule for judicial review purposes, CEG Melise against CPSC.
As a starting point, I think that's excellent. I wonder in the first sentence if we want to make reference not just to opportunity to participate through the submission of comments and then publishes a final rule after considering those comments, but also mention the notice.
Well, it says solicits comments. That's how you do it in the notice. Oh, you mean the final notice?
No, I mean, I mean, with interim final rulemaking, you solicit comments, but you don't issue a notice first.
Well, I think a certain Supreme Court case suggests that when you solicited them, you were.
Yeah, I know. Well, you and I.
No, I don't know. I
I'm
think
not
we should
defending
take the IFR out of this. The IFR is challengeable on the same way, I think, as everything else we're saying. And the timing and all that should start in exactly the same way. An interim final rule, or at least what we're calling an interim final rule, recognizing that agencies can put any title on a Federal Register notice that they want, it comes with, it just operates in what Little Sisters recognized, is that it operates both as a sort of temporary final rule, but also as an NPRM. And to the extent that it's operating as an NPRM, it just follows any other rule. And to the extent that it's immediately effective, it can be challenged then.
I can agree with you, Allison, with respect to the Little Sisters interim final rule. But as we talked about in the first hour of this meeting, you know, one of the things that is evident is that there are, you know, with the label interim final rulemaking is used for a whole hodgepodge of different sorts of procedural postures. And so I think it's at least important to acknowledge
how about
that, as a possibility, you know, rather than leaving it out altogether, you know. And I'm fine with putting fuzzy language that says may raise issues, but you know.
How about it does not address situations, it does not address rules, or does not necessarily apply to rules issued pursuant to 5 U.S.C. 553b3.
It does say that, effectively.
Yeah, but it doesn't use type. I would prefer
it also
to
gets back,
get rid of
Allison, to the fact that some of these agencies are putting out rules like this based on their organic statutes, not based on the APA. So we've got a problem if we reference a particular provision in the APA.
Okay, how about it does not necessarily address issues ruled, final rules issued without prior notice and comment.
Well, then you've got the label of final rules.
Why don't you
just say rules?
Why don't you put my language on the screen? I'm not sure it poses the problems that Allison's worried about, because it says what we're not doing. You want me to read it to you?
Yeah, let me have Mark. Let me have Mark and Ron work together to get the language on the screen, and then I want to call on John Duffy.
Okay.
Whose hand was up?
Once again, this recommendation addresses judicial review of rules that are issued through a process in which the agency solicits comments and then publishes a rule after consideration of those comments. The recommendation does not address situations such as direct final rulemaking and interim final rulemaking, in which an agency publishes a rule in the Federal Register, but invites post-promulgation comments or objections. See Administrative Conference Recommendation 95-4. Those situations can present problems of determining the effective date of the rule for judicial review purposes. CEG Melise versus CPSC.
So Melise is M-I-L-I-C-E.
Yeah.
Can I speak out of turn and make a comment?
Yeah, actually, let me speak out of turn first. Did you intend on the second line there to include the word final and then publishes a final rule after consideration of those comments? I don't think you had final in there to begin with, but maybe it needs to be in there or maybe not.
I will claim to have meant that, yes.
Okay. Allison, you wanted to speak out of turn, and then John Duffy has been very patient. And then Bill Funk.
Oh, wait a minute. That isn't true of direct final. You don't publish the final rule. You may confirm that you're sticking by it. So we'll have to think about that later.
Allison, did you want to speak out of turn?
Yeah, I'm just wondering, and maybe Ron and who knows about 95.4 or John can tell me I shouldn't be concerned, but why we would be excluding interim final rulemaking from the scope of this recommendation. Because I think the interim final rule would benefit from a lot of the points in this recommendation, for the same reason that I don't think that the concern raised in the lease applies to interim final rules. So do we actually want to exclude them here? I mean, since we're saying such as, could we just say such as direct final rulemaking, which is obviously a non-inclusive term, and then it wouldn't just not mention it. You wouldn't have to say whether we should include them or not, but I'm just wondering why we don't want to include them.
How about this? How about such as direct final rulemaking and in some cases, interim final rulemaking? Again, getting to the point that not every interim final rulemaking follows the model of Little Sisters of the Poor.
Well, just to follow up on Allison's question, what is a situation where you would not want the main text of the recommendation to apply?
I guess I got to think about that. Let me think about that for a minute, and let me have John Duffy speak.
So this might help in this spot. So I would think we should put the following sentence right before the cite to the lease. So after Ron's language and before Melise, something that says, and I'll read it quickly, and if everybody objects, then I'll withdraw the suggestion, so you don't have to type it. Parties should be aware that statutes of limitations may begin to run upon publication of any rule, parentheses, whether styled as a direct to final, comma, interim final, comma, temporary or otherwise, close parentheses, notwithstanding the agency's maintaining a period for objections or comments to the rule after its publication. And then C. Melise is the site, of course, for that proposition. It's sort of carefully couched to be, may, and it covers sort of the whole field of these things that have binding effect, these rules that have binding effect and are going to go into effect on a date certain. And parties should be aware of that. So I think that might be helpful.
Could you read that once more? I think I might be with you, but.
Okay, so maybe I'll read it slowly and maybe it should be typed in then. Parties should be aware that statutes of limitations may begin to run upon publication of any rule, open parentheses, whether styled as a direct to final, comma, interim final, comma, temporary, comma, or otherwise, close parentheses, notwithstanding the agency's maintaining a period for objections or comments to the rule after its publication. And then C. Melise. I can type that into the comment. It could be cut and pasted into the document.
Yeah, why don't you do that?
So John, your idea is just to say, like, Melise happens, we're not addressing it, be careful.
Yeah, basically, and really, our recommendation, which is that it should start upon publication, is actually consistent with the Melise holding. So we're just warning people that, look, though we have not taken a position on this, we haven't taken a position on it, the DC Circuit has, and it may very well start to run on the date of publication, even though we're not addressing that situation. This recommendation isn't addressing this situation, but it may very well begin to run upon publication. See Melise, and that is the holding of Melise, because Melise actually cited the case law that John Siegel talked about promulgation being equivalent to publication. It cited that DC Circuit case law, which is sort of the main point of John Siegel's recommendation, the original recommendation way back when. But, you know, that stuck to it stuck to its guns and said it applies to this direct to final thing as well. So I'll start typing.
Yeah.
You start typing. Let me call on Bill Funk, and then I also have a proposal that I think may, at least to my mind, may help. But let me call on Bill Funk first.
I had a little problem with the word effective date, or the words effective date in Ron's language, because especially if you then say see Melise, because Melise, there was no question what the effective date was. It just happened to be a different date than the promulgation date. And the question was, which of those two dates triggered the beginning of this running of the statutory limitation? And the court said it was the promulgation, the publication date, not the effective date. So I just think the effective date is the wrong word there, and should probably say, I can't read it because it's too small on my screen, but the date that begins the running of the statute of limitations.
Yeah. Event date? Because that's what the recommendation.
Yeah, since the whole recommendation is built around event date, can present problems of determining the event date for judicial review purposes. Yeah. Do we need of the rule there if we mention event date?
For purposes of judicial review of the rule.
Okay. Okay, John Duffy's language is now in the chat. So let me give Mark a second to put that into the footnote. And then I also have a proposed change that I think addresses my concern about interim, final, and temporary rulemaking, but may also address Allison's concern. Maybe. Okay. So, Allison, I take your point about some portions of the recommendation being of value in many instances, if not most instances, when we're dealing with interim final rulemaking. On the other hand, if there's one thing that the earlier conversation drove home for me, and also, you know, conversations with Nina, and I know Nina was particularly focused on Melise, but I think she was the one that originally brought up interim final rulemaking. The conversation earlier today, you know, flagged for me that when you're talking about labels like interim final rulemaking or temporary rulemaking, that they're used in lots of different ways, some of which are not the Little Sisters of the Poor scenario. I continue to be a little bit concerned. And so I feel like we need to include some reference in there. I'm wondering, and even though I know that passive voice is not as desirable as active voice, I'm wondering if we can accomplish this, or, you know, sort of address my concerns a little bit by, instead of using, you know, with respect to this second sentence, instead of starting it with the recommendation does not address situations, if we said, instead, if we started it just with situations, comma, such as direct final rulemaking, comma, interim final rulemaking, comma, and temporary rulemaking, comma, in which an agency publishes a rule in the Federal Register but invites post-promulgation comments or objections, may raise unique issues regarding statutes of limitations in some circumstances. You know, whether or not we then need those situations can present problems of determining the event date for purposes of judicial review of the rule, you know, well, maybe we don't limit it even to that. We just say, hey, there may be some unique circumstances with these labels. There may not be unique circumstances with these labels. You know, maybe we then say, you know, you know, we just sort of leave it at that, which I think carves out those circumstances as, you know, with particularly with John Duffy's added sentence. You know, we're clearly carving that out and saying, you know, hey, there's some weird circumstances that this recommendation isn't addressing, while simultaneously not trying to pin down exactly what those circumstances are. Because I think that was why we ended up with the less is more approach with the recommendation, is because we couldn't get comfortable with pinning down exactly what circumstances raised our concerns. We knew the Melise case, we knew the ACUS recommendation, but we weren't sure about all the permutations. Bill Funk, you've got a comment on my suggestion.
Again, I can't read the actual text because of it's so small on my screen, but as I listened to you, it seemed like you took out the language this recommendation does not address, and just substituted the idea that there are unique situations that raise particular issues in some circumstances, but doesn't specifically say we're not addressing them. And I thought that was really the whole point here, was to say what we were not addressing.
True. Well, although the first sentence says this recommendation addresses.
Yeah, and then you say there's unique circumstances. Don't say how we're going to deal with them.
So maybe after the citation to ACUS recommendation 95-4, we say something to the effect of, you know, this recommendation does not address all such circumstances.
Maybe.
I mean, I get that it leaves it fuzzy, but that was part of the problem. We don't know what it doesn't cover.
Well, actually, I thought we did know what it didn't cover. It didn't cover anything that didn't have this prior opportunity for interested parties to comment, because that's what we limited our recommendation to. I mean, my response to Allison, and her concern that for what she thinks of and I think of as interim final rulemaking, ought to be, the statute ought to trigger right when it's issued, published in the Federal Register. That I think that would happen anyway. We don't need to address it. We can say this recommendation doesn't address it, but we don't need to address it because that's what's going to happen anyway. It's not like we're saying that what we're recommending won't apply. It's just saying we're not just addressing that. So that's the way I deal with Allison's thing. It's not to make less clear what we're not addressing. I think we ought to be clear about what we're not addressing. But the fact that we're not addressing it doesn't mean we're taking a position that it shouldn't have the same effect as what we are recommending, which is not taking a position on it.
Okay. So you would add back, this recommendation does not address before situations, which I think I understand what you're saying, and I think I'm fine with.
I'd go back with essentially Ron's original language, except for the effective date issue.
My language is still there, isn't it? We only added.
No, it got kind of messed around with a little bit. So we need to add this recommendation does not address before situations.
Oh.
And then it's only sort of a wordsmithing issue is we use direct final rule in one place and direct to final rule in a different place in the same footnote. So I think we ought to be consistent, and in John Duffy's language where he says direct to final, say direct final, just because to be consistent.
Okay, there's also one little grammatical point. So in that second sentence, this recommendation does not address situations such as direct final rulemaking, interim final rulemaking, and temporary rulemaking in which an agency publishes a rule in the Federal Register, but invites post-promulgation comments or objections, comma, which may raise unique issues. Okay, everybody take a look at the footnote. Happy with the footnote, concerns about the footnote? Ron Levin, please go ahead.
Yeah, we started, so speaking, referring to John Duffy's insertion, we started off with Alan saying, there's a real problem here. We ought to see if we can object to it. And the way John wrote it seems to me to do the opposite. It seems to say, well, Melise got it right, and you should just live with it. And I don't think that's I thought we wanted to say the first. And so I would suggest you might tweak John's language by saying that statutes of limitations may be construed to begin to run upon publication, etc. And such interpretations may have the unwelcome effect, the questionable effect, debatable effect of forcing parties to seek judicial review before the period for comments has been completed.
Do we want to include that editorialization?
That's the question I'm putting on the table.
Sure.
But it doesn't have to editorialize. It could just say, that will be the effect. You consider whether you like that effect.
John Duffy and then Allison Ziva.
So I thought Alan's point was different. I thought Alan's point was that he didn't want the agencies to be arguing that the challenges that now, in light of cases like Melise or Melise in particular, are going to be filed while the comment period might still be going on. He didn't want the agencies to be able to argue, oh, no, it's not right, or you haven't exhausted administrative remedies, or it's, you know, some other bar to judicial review. Meanwhile, the statute of limitations is running. I thought that if we really wanted to address Alan's point, and I agree, my sentence does not do that. I wasn't intended to do that. You would say something like, after the cite to Melise, you would say in such situations, agencies should not argue that judicial review of the rule is barred by doctrines of ripeness or finality or failure to exhaust administrative remedies. That's what's off the top of my head, drafting of that. I would not, so, you know, the sentence that Ron's adjustments to my sentence, I mean, it really is editorializing at this point, and I haven't given much thought about Melise, whether it's right or wrong. I can understand the argument that it's right, even though I think the parties got a harsh deal there. They could have probably done other things to get judicial review. But I think Alan's point was we just don't want the agencies at the same time trying to whipsaw the plaintiffs and saying that it's not it's not ripe, and then when it is ripe, the time's expired.
Sorry, I muted myself for a second. Allison?
There's now so much on the screen. I can't even see the end of the paragraph, and I'm not really, I'm a little bit lost about this footnote, but also at some point the footnote becomes so substantive that it maybe belongs in text. But I really don't think we should editorialize about it. I did not take us to be saying that Melise was incorrect. You know, as a matter of policy, I guess people could go either way. As a matter of law, it seems to me it was correct. But I thought John was just trying to basically state, I mean, the law is whatever, on this issue, the law is whatever the DC Circuit says it is, because the CPSC cases go to the DC Circuit. So I thought his goal in his draft sentence was just to say, here's the law, be careful or beware. And I think if we want to say that, I think it would be a good idea to say it, but we should certainly say it without editorializing about whether it's a good or a bad idea. It just doesn't belong that's just not the place for us to editorialize. We sort of editorialize in our main comments that result in a recommendation.
So two things. Number one, we have a request. Could somebody please find the citation for Melise and put it in the chat? Someone who's on the phone is not aware of the case and would like to be able to go look it up. I am of the view that we should not editorialize regarding Melise. As much as I personally happen to think that Alan is right, that agencies should not argue judicial of the review of a rule is barred by doctrines of rightness, finality, and exhaustion. On the other hand, that strikes me as somewhat non-germane to this recommendation, and also opens up a whole body of case law that I just don't think we're really prepared to deal with in this recommendation. So in the abstract, I agree with Alan that agencies shouldn't whipsaw litigants, but on the other hand, it just seems beyond the scope of this recommendation.
So I tend to agree with that, and I will withdraw my previous editorial proposal either, but I would like to keep construed in there as it may be construed that way, which not exactly the same as saying that is what we think it means. But that isn't really editorializing, it's just a statement that the courts may do that.
Right.
That seems fine.
So, does that mean we should
Can I
take
just ask,
out that? Go ahead,
is there a
Allison.
way to get the whole? Is there a way to get that whole footnote on the screen at once? Like if you could click on the space between
The whole
pages.
footnote is on the screen.
Oh, it is. That's the end. Okay,
That's
I
the
couldn't
end.
tell. I didn't know that.
It's just that last sentence. I think we decided to take out. Am I right that we decided to take out that last sentence? Is editorializing too much? John Duffy, I see your hand up.
Before you do that, I don't care that much. It was not mine so much, but Alan Morrison's. But I do think Alan Morrison was onto something. I awkwardly framed it as agencies should not argue, which I didn't like either. I just couldn't think of anything better. Why not, instead of in such situations, if statutes of limitations begin to run, then judicial review should not be barred by doctrines of ripeness, finality, or failure to exhaust remedies.
I have the same objection.
You think it's still?
I mean, I feel like it's beyond it's not germane to this recommendation.
Okay.
And because those bodies of law are so incredibly fuzzy and mushy and everything like that, I just don't feel like it's appropriate for this recommendation to make a statement like that.
Well, I was trying to stick up for my old colleague, Alan Morrison.
Yeah.
Not here.
I love Alan Morrison, and I have the same concern in the abstract. It just,
But also, we shouldn't be making a recommendation in a footnote of the preamble.
Okay, that's fine with me.
That's just such, and it's such a huge recommendation.
Kristen, you can tell him that it fell off the table.
You can blame me. Totally blame me. I'm fine with that. I'm happy to talk with Alan about it. Okay.
We could assign Alan to do an ACUS project reviewing direct final rules and interim final rules to find out whether we need a recommendation.
You know, since it's been, you know, over 15 years. No, since it's been 25 years since we last had something on direct final rulemaking, you know. Which, I mean, Ron, your ACUS recommendation in 1995 was fantastic, but it has been 25 years. Okay, let's, everybody take a look at the footnote. Is everybody fine with the footnote?
By the way, Michael Asma was co-consultant and he did the interim final part. I did the direct final part.
Got it. Any objections to the footnote? Okay, seeing none, I know we've been going for a long time, but I'm hoping we can knock out these last couple of things in just a matter of a couple of minutes. So rather than taking a 10-minute break, let's see if we can do that, if that's all right with everybody. So we've got two last things that we need to address. So yeah, Mark, this paragraph that's currently highlighted just needs to go away. We need to scroll down to, if I can find my own notes here. We already dealt with the other change in recommendation 2. We just now need to go to 4G, I believe. Peter Strauss raised the point, I believe it was in the plenary, that many of the actions we're talking about, especially since we're talking about rulemaking, aren't issued as orders. An order has a definition in the Administrative Procedure Act that is much narrower than the actions we're talking about here. So John Siegel proposed that we replace issued the order with took the action. Again, this was, you know, that there was some discussion about whether this could be resolved by the Committee on Style because it's relatively non-substantive beyond that, but it's sort of on the bubble between substantive and not. So we thought we'd run it through the committee. Does anybody have an objection to this change? Seeing none, let's go ahead and make that change, please.
Is there any possible application to adjudication that we need to avoid doing?
You know, I mean,
It should apply in either case.
yeah.
I think thinking back through my research, I think the question of when you had these situations where a statute says serve the document initiating review simultaneously, I don't recall that those were limited to one particular kind of agency action.
Okay. Objections. Okay, then let's move on to the last item. The last item was Sally Katzen threw out this idea of deleting the word general. It's not entirely clear from the transcript or from the video of the plenary that Sally was making an affirmative recommendation as opposed to raising a question about you know, sort of what general was doing in here. I don't feel strongly either way. I don't know that necessarily removing the word general accomplishes very much. And again, I will reiterate my general concern that the more changes we make that are beyond the purview of the direct final and interim final rule problem, then the more opportunities we have for making the plenary vote that's going to be done by email more complicated. On the other hand, I don't feel strongly either way about keeping general or removing it. So, my proposal would just be to leave the word general in there and not make this change. But on the other hand, I'm prepared to be persuaded otherwise. Thoughts or concerns?
Kristen, Matt, maybe Mark, does this, does the word general appear elsewhere in the recommendation, in particular in the preamble, such that it's sort of a defined term? It did at one point. I
believe it did.
That would counsel against taking it out. See, right, see, it refers to on the screen there, a general statute. That's why that word, I believe or suspect, was put in there.
Got it.
So you probably, I would counsel in favor against taking it out. And I doubt Sally Katzen's going to lose sleep over this one.
Well, my memory of the discussion at the plenary was that she was concerned that calling this a general judicial review statute, as opposed to the sort of technical amendments that we're making, would raise lots of eyebrows in terms of ever trying to get something published, or people viewing this as a good thing or a bad thing. If you're talking about, oh, ACUS has come up with a new general judicial review statute, right? Oh no, last thing we want is a new general judicial review statute. So that's why I think she was concerned about it. It seems to me, with search and replace, you can get rid of it and change it pretty easily. And I just think, because I view these as technical amendments, to just refer to these things as technical amendments.
I don't have a problem, Bill, with what you're saying. If we had made this adjustment either on the floor of the plenary, or if we had made this adjustment previously in committee, it's purely because of where we're at right now that I have concerns about it, because we're talking about tinkering not just with one word right here, but we're talking about tinkering with the preamble too.
I understand, but the question is it tinkering or is it just denominating? I mean, the question is this a general judicial review statute? And that's in the sense of it's dealing with judicial review generally, or is this technical amendments to the judicial review statute? And I think it's a more accurate and less inflammatory way of referring to it. And I think it's responsive to what Sally said. And I didn't hear any pushback in the plenary to her suggestion that this was not a good way to characterize it.
So is your suggestion that we just simply replace the word general with technical?
But they're all technical.
Yes.
Everything's
technical. There was a point also at which the committee did not like the word technical to characterize what this recommendation is doing.
Yeah. So what about supplemental or general supplemental?
I don't recall what the objection was to technical, but I mean, I don't.
I think I do remember this, and maybe John Siegel remembers too, but I think that, that technical sounded too limited.
People use technical to mean like unimportant, like she got off on a technicality.
John,
well,
go ahead, please.
That's exactly what these are.
In the report, I don't think all of these definitions made it into the preamble. There's a little bit of it. In the report, I discussed the many specific judicial review statutes in the US Code, and that is defined as statutes that cover either just a single agency or that cover judicial review under a single statute, even if that statute applies to multiple agencies. And general judicial review statutes are statutes that cover multiple agencies operating under multiple statutes. So this would be a general judicial review statute in that contrast between general and specific. I think the word we previously objected to was housekeeping. So anyway, that's where I think, that's why I wrote this. That's why I used the word general. I think it's fine. I'm not going to go to the wall on this. If someone wants something else, I'm not going to stand in the way. But I think general is fine, and technical. I mean, if someone wants technical, I'm not going to object to it. I would just say you need to look at each place where general occurs and see if technical would fit there. But I'm not going to fight hard about this.
Ron, you're talking, but you're muted.
Yes, thank you. I don't like technical because it sounds like we have low self-esteem about what we're doing. We think it's important, even though it is a little arcane.
Okay.
I think general's just meant to mean that it's not, I think, CPSC specific or NISA specific or ISC.
But Allison, what I wanted to say is this is different from the Hobbs Act, because the Hobbs Act applies to many agencies, but it's the primary statute with respect to those agencies, whereas what we're doing is offering a backup provision that applies wherever there's ambiguity in the respective specific judicial review statutes. And so that's why I think it is saying this general statute that would be enacted would supplement those particular ones wherever they have ambiguities that we are out to resolve.
What about the possibility of no adjective at all?
Well, in 5, that's okay, but what about all the others? Well, 4,
I don't know. I don't know. That we have to go through and look, which is one of the reasons why I'm not happy with the idea of a change at all, is because, you look at this and as Matt pointed out, on page 2 in particular, around line 22, we define what we mean by judicial review statute. And so it's a defined term. So, and then.
And throughout, we also refer to specific review statutes also. So there's that, it's a contrast on purpose.
Yeah, I mean, so it's not just a matter of deleting an adjective or changing an adjective. We're tinkering with a defined term, which is as distinguished from another defined term. I see John Duffy's hand is up. Let me recognize John, please.
So I think at some point we should just take a vote on this. I kind of agree with you, Kristen, that I would leave in the word general. I think Sally Katzen, I mean, the word general has a lot of different definitions. It could mean comprehensive, which I don't think we're intending it to mean that. We're intending it to mean general as defined in the preamble to cover, all the agencies. But it's not a comprehensive statute. And, therefore, I support just leaving the word in and not reading the word general as comprehensive, but just reading it as narrowly construed and defined in the preamble.
Can I ask a quick question? Kristen, did she flag it just in that one place or throughout?
I believe she just flagged it in that one place.
I think she flagged it in that one place. And my guess is, and I would be happy to say this to her, I think she saw the reference in this one place and did not see the context in which it appears.
That's what I was thinking. Though I think when I spoke out of turn, I interrupted Bill.
Actually, I've got,
I interrupted.
let me ask
her.
Bill. Go ahead, Bill, and then Ron Levin, please.
I said, I'm not even a member of the committee, so I'm hearing most of the members of the committee saying they like general. That's fine. That's your choice. I mean, the little memo from Bobby said that raised a point about the use of the word general when referring to the judicial review statute referenced throughout the recommendation. It's anyway. But as I say, I'm not a member of the committee. I hear what people are saying, so I rescind.
Ron Levin, go ahead, please.
I agree with the way the conversation is flowing. I think we should leave it as it is because it's been that way throughout the whole debate. I would suggest that Matt or Reeve or Mark or someone should put in the packaging documents that it refers to a general jurisdiction, by which we mean one that serves certain purposes, and it doesn't mean it's comprehensive, doesn't mean it's changing the world, doesn't mean it's anything that you should get excited about. But that's just in the labeling and the materials that introduce it, and we can leave the recommendation as it stands, and I doubt that any people are going to read the recommendation alone and have the panicked reactions that we've been warned about.
Given all of this, that seems to be, I agree with Ron, that seems to be the direction the consensus is heading, that we just leave it alone. Does anybody want to, and Bill's kind of backed away from it. Does anybody else want to really push for making this change? Okay, with that, I'm going to conclude that we don't need to hold a vote, that we can just decide to forego this change. And that's everything that I have on my agenda. Have I missed anything, Mark or Matt or Reeve?
Let me defer to Mark and Reeve on that one. I don't think so.
I don't believe so either. No.
Okay, so with that, I think we're pretty much done. And we can, do we have to, I always forget this, and I apologize for the fact that I always forget this, but do we need to hold a vote to move this back out of committee?
You should.
Okay. In that case, so again,
you could do it by, you could just do it by unanimous consent. You can just ask if there's any objection.
fine. Let's do that because Zoom makes things so complicated. So yeah, I'm gonna move by unanimous consent that we move this back out of committee and to the plenary for a final vote. If anybody objects, who has a vote, please let me know. Just as a friendly reminder, the people who have votes are ACUS members, they're designated alternates, or government members, public members, senior fellows, liaison representatives, and special counsel. Does anybody who's on that list have an objection to moving this out of committee? Seeing none, I'm going to declare it moved and so moved, and we'll send it back to the plenary for a final vote. Thank you, everybody, for your hard work, your consideration, your patience, all of the above. Greatly appreciated. And to John Siegel in particular, as our consultant for all of his hard work in putting this thing together to begin with, as well as such a wonderful report. Thank you, everybody.
And let me just say that on that subject, that John's source book will be going to GPO soon for publication, and we will circulate it far and wide, including to the members of ACUS and especially this committee.
And with that, I think we're adjourned. Thanks, everybody. Take care. We'll see you in the fall at some point.
See ya.
Thank you.
Good job, Kristen. Thank you.